Yes, I'm happy to. Thank you so much. So good afternoon to my colleagues on the East Coast, and good morning to those elsewhere. For those of you who don't know me, I'm Joanne Stone. I'm the chair of OBGYN at Icahn School of Medicine at Mount Sinai here in New York City, and also serve as the president for the Society of Maternal-Fetal Medicine. On behalf of myself, SMFM's executive committee and the board of directors and our SMFM staff, we welcome you to today's webinar. Today we come together as leaders in high-risk pregnancy to learn more about the dramatic shift in access to abortion services that our patients face in the wake of the Supreme Court's decision to overturn Roe v. Wade. We all wish we didn't have to be having this discussion, but it's a really important discussion to have. As we kick things off, we ask you go to the URL on this slide and link to the chat to participate in the polls we've created for today's convening. And the polls really are essential for this interactive type of Zoom call. So I have the first question up is, where do you practice? So if you can drop a pin where you take care of patients, it'll self-populate. So as let me just see, okay, so as hopefully this will get more and more populated, the purpose of today's convening is really to create a forum for you to hear from the nation's leading experts in reproductive health on the Supreme Court's decision in the Dobbs v. Jackson Women's Health Organization case, their plans for future litigation related to abortion access, and initial analysis of the decision's impact on MFM practice. We will also hear about what SMFM is doing to provide resources for members in the wake of the Supreme Court's decision. As you can see from the map, the folks in the virtual room certainly have very different experiences in the last few weeks. We're sort of all over the place, a little bit less, I guess, sort of centrally, but it's getting more populated. Those of us in states with permissive abortion laws may have begun to see patients traveling for abortion care. I know at my own institution, we've seen sort of an uptick of this in the last few weeks. We perhaps continued on or started having conversations with colleagues and hospital leadership on how best to manage a potential influx of patients. We've advocated for institutions to take a stand. And I know many institutions have been really, really super supportive of this. For our colleagues in states that are restricting access to abortion, you've been managing a shifting legal landscape. Perhaps you're meeting with hospital leadership to discuss how you'll take care of patients. I know that's happening all over. And really, I just cannot imagine how you're coping with counseling patients through this uncertain time. Then there are colleagues from Texas who I can only guess are here to welcome some of us to the club that none of us really wanted to be in, and they've been living in for almost a year. Just in terms of learning more and staying up to date, before I turn the webinar over to our esteemed presenters, I want to affirm that the Society and its leadership are committed to fighting for you and your ability to provide evidence-based, quality, and compassionate care to patients. We know that this will not be easy or a quick fight, but we know that it's critical both to protect our patients and maintain the integrity of the patient-clinician relationship. To learn more about what SMFM is doing, I encourage you to visit the URL on the slide and linked in the chat. If you'd like more information, have an inquiry, would like to share an idea, please email the address on the slide and include it in this chat. And then just in terms of code of conduct, we just want to remind attendees that SMFM's code of conduct is outlined on this slide. We appreciate your participating in today's event in a respectful way. And again, thank you again for joining today's event. I'm going to turn it over to SMFM's Senior Director of Advocacy, Becky Abbott, who many of you probably already know, to introduce our speakers. Thank you so much for doing this.
Thank you, Dr. Stone. As Dr. Stone mentioned, my name is Becky Abbott, and I am SMFM's Senior Director of Advocacy. I have the honor of working to advance SMFM's advocacy agenda in collaboration with you and our members. A big part of that work is advocating at the state and federal level to protect and expand access to reproductive health care services, including abortion. As I review a few housekeeping items, we'd appreciate learning more about how the Dobbs decision is impacting your practice. And I appreciate some of you already putting your answers into the poll. We just want to know how your day-to-day practice is being influenced. So as you're doing that, a few housekeeping items. We're in a Zoom meeting format, but to control noise, we've muted you all upon entry. In order to speak during the Q&A, if we have time, we'll ask you to raise your hand and we'll take you off mute. We have 3 incredible panelists lined up. We encourage you to make liberal use of the chat feature during the presentation to ask questions, share experiences, and present ideas. SMFM staff and panelists will be monitoring the chat and responding. At the end of the panelist presentation, as I said, we hope to have enough time reserved to open the floor to Q&A from our members. And reminder that the meeting is being recorded and we will post the recording following today's presentation. Real quickly, thank you guys so much for sharing how the decision has impacted your practice. Some of you have been really feeling the impact, while a fair number of you are proceeding with business as usual. There's certainly a wide range of experiences depending on where you practice, your institution's policies, and your practice model. And the weeks and months ahead, we'll be trying to find ways to continue to do this kind of pulse poll to see how changes in state law are impacting your practice and what kind of supports you might need. And without further ado, I am pleased to introduce you to all 3 of our panelists. In the interest of time, I'm not going to read their full list of accomplishments and accolades. However, I encourage you to review their full bios, which you'll find linked in the chat. First up, we'll hear from Alice Wang. Alice is a staff attorney at the Center for Reproductive Rights. At the center, she litigates reproductive rights cases in both state and federal court. Alice and her team at the Center for Reproductive Rights are fierce defenders of reproductive rights. And in the wake of the Dobbs decision, they have been working tirelessly to bring cases to halt or delay state abortion bans from taking effect. On a personal note, the SMFM team had the pleasure of partnering with Alice to draft our amicus brief in the Dobbs case, and we are so grateful to her for her expertise and graciousness throughout that process. Second, we are thrilled to have Skye Perryman with us today. Many of you might know Skye from her time as General Counsel at ACOG. She is now President and CEO of Democracy Forward, where she works with her team to advance democracy and social progress through litigation, policy engagement, and regulatory advocacy. We are pleased Skye can be with us today to help us better understand what the decision might mean for the practice of high-risk obstetrics in the months and years to come. And finally, we'll hear from SMFM's own Dr. Erica Warner. In her day job, Dr. Warner works to optimize pregnancy outcomes through her work as the chair of the OBGYN department at Tufts Medical Center. As an SMFM volunteer leader, she works to achieve the same goals by leading SMFM's advocacy work as chair of our Health Policy and Advocacy Committee, and she's also a member of SMFM's Reproductive Healthcare Advisory Group. As such, Dr. Warner is perfectly positioned to provide an update on SMFM's work to protect abortion access now and in the future. I hope you're as excited to hear from the panel as I am. And so with that, I will turn it over to Alice.
Hi, everyone. Sorry, it took me a second to come off of mute, but my name is Alice Wong. My pronouns are she, her, and as Becky said, I'm a staff attorney at the Center for Reproductive Rights, where I represent the Jackson Women's Health Organization in the Dobbs case. So the Center, for anyone who is unfamiliar, is a global human rights organization that uses the power of the law to advance reproductive rights as fundamental human rights across the world. And our US litigation team primarily represents independent abortion clinics across the country in lawsuits that challenge state-level abortion restrictions, but we also do work related to other areas of reproductive and maternal health. First, I just want to thank SMFM for convening this space and all of you in the audience for the excellent care that you provide to patients every day and for also advocating for the reproductive health rights and justice movement. So I'll just start by giving an overview of the Dobbs decision. As most of you already know, the court abandoned nearly 50 years of settled precedent and explicitly overruled Roe v. Wade as well as Planned Parenthood v. Casey. So in other words, the court has rescinded constitutional protection for the right to abortion. Legally speaking, moving forward, that means that abortion restrictions in federal court under the federal constitution would be subject to the lowest level of scrutiny, which is called rational basis review. So under that standard, abortion restrictions are presumed valid and will be upheld as long as they're rationally related to a legitimate state interest. So in the majority decision, the court wrote that legitimate state interests include both those that have been previously recognized, like protecting potential life and maternal health, as well as new interests that have no grounding in facts or science, such as the mitigation of so-called fetal pain. So that's particularly relevant here because SMFM, along with a number of other professional health organizations and esteemed scientists, submitted an amicus brief that debunked the pseudoscientific claim that a fetus is capable of experiencing pain prior to viability. Unfortunately, like much of the other robust scientific and social scientific evidence that was provided by various amici in support of Jackson Women's Health Organization, all of this science was ignored by the court. So Dobbs was a cataclysmic change in the law and a devastating loss. Never before has the court taken away a fundamental liberty right that generations of Americans have come to rely upon to organize their lives. And while it's important to acknowledge that women are not the only people capable of becoming pregnant, it's also important to recognize that this is the greatest setback to women's rights in our nation's history. So I'll spend a little bit of time just breaking down the Dobbs decision. The justices voted 6-3 to uphold Mississippi's ban on abortion after 15 weeks of pregnancy, and 5 justices voted to fully overrule Roe. The majority opinion was written by Justice Alito and joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Roberts wrote separately to concur in the judgment only, meaning that he didn't agree with the majority's reasoning and would not have gone so far as to overrule Roe. Justices Kavanaugh and Thomas also wrote separate concurrences, and Justice Breyer wrote a dissent that was joined by Justice Kagan and Justice Sotomayor. The controlling opinion was almost identical to the draft opinion that had leaked back in May. As I mentioned, it overrules Roe. It holds that there's no constitutional right to abortion, and it sets forth a profoundly regressive and disturbing view of what it means to be free and equal under the Constitution. So the court departs from the premise that unless a right is specifically enumerated in the Constitution, it's only protected under the 14th Amendment's Due Process Clause if it's deeply rooted in the nation's history. And then the court adopts an extraordinarily narrow view of what it means for something to be deeply rooted, which essentially asks only whether the right was protected by a majority of states at the time that the 14th Amendment was ratified in 1868. So this, of course, ignores the fact that the ratifiers of the 14th Amendment were white men who didn't view women or people capable of becoming pregnant as full and equal citizens. And so they really didn't have a voice in the political process at all. The bottom line is a constitutional vision that forecloses any possibility of progress or expansion of civil rights to those to whom they were previously denied. So I think the dissent put it quite well when they said, because laws in 1868 deprived women of any control over their bodies, the majority approves states doing so today. Because those laws prevented women from charting the course of their own lives, the majority says states can do the same today. Now, the majority claims that its decision can be cabined to abortion, but as the dissent correctly points out, the majority's reasoning actually applies equally to other liberty rights related to bodily integrity and personal autonomy. So in the dissent's words, either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are also under threat. It's one or the other. The majority didn't attempt to justify its radical departure for precedent on the basis of any changes to the underlying law or facts. And it discounts the reliance of people capable of becoming pregnant on the right to abortion to exercise their self-determination and to fully participate in the economic and social life of the nation. And finally, I just want to say that just as outrageous as what's in the majority's decision is what is missing from it, which is any mention of the impact of its ruling on all people capable of becoming pregnant. So I'll briefly just go over the sort of top line points in the other opinions. In Justice Thomas's concurrence, he essentially says the quiet part out loud with respect to the other important liberty rights that are undermined by the court's decision. So while the majority claims that its ruling is limited to abortion, Justice Thomas acknowledges that when presented with the proper vehicle, he would go further to revoke all liberty rights protected by the 14th Amendment's Due Process Clause. So that would include the landmark decisions of Griswold, which guarantees the right to use contraception, Lawrence, which protects the right to engage in consensual intimate conduct without state intervention, and Obergefell, which established the right to marry someone of the same sex. In another concurrence, Justice Kavanaugh insisted that the court is taking a neutral position by returning the issue of abortion to state legislatures. But this boils down to the view that once a person becomes pregnant, the Constitution no longer confers any guarantee of liberty, and rather it's for state legislatures to weigh that pregnant person's interests against the state's interests. So as the dissent pointed out, when the court decimates a right women have held for 50 years, the court isn't being scrupulously neutral. Instead, it's taking sides against women who wish to exercise the right and for states like Mississippi that want to bar them from doing so. As I mentioned in the beginning, Justice Roberts would have upheld Mississippi's 15-week ban, but discarded the viability line from Roe and Casey, and he wouldn't have reached the question of whether the Constitution protects the right to abortion. Last but not least, I would say if you choose to read any part of this, I think almost 200-page decision, I would spend that time on the dissent. It names the profound retrogression and harm inflicted by the court's decision. It recognizes that the harm will not fall evenly and will instead be disproportionately felt by the most vulnerable and marginalized communities. It makes clear that our liberty rights are interconnected and that abortion rights can't be so neatly carved out from the whole scaffolding of liberty interests protected by the 14th Amendment. And in the dissent's terms, they say, think of someone telling you that the Jenga tower simply will not collapse. And finally, the dissent also called out the court for breaching the rule of law and undermining its own legitimacy by reversing settled precedent based on nothing more than a change in its composition. So turning now to the implications of the Dobbs decision, as we in the reproductive health rights and justice movement anticipated, there has already been utter chaos in the just over 3 weeks since the decision came down. States have wasted no time to ban abortion by immediately moving to enforce trigger bans and pre-roll bans that have been on the books for some time, and also filing motions to lift injunctions against other more recently enacted abortion bans in pending cases. So some clinics have already stopped providing abortion care, and unfortunately, others will likely be forced to do so in the coming days and weeks. Our clients in states where there's currently still abortion access are absolutely flooded with calls from desperate patients seeking abortion from states that have gone dark. So while it's only been a few weeks, it has already engendered an urgent public health crisis across the South and Midwest. And it all goes to show that contrary to the Supreme Court's claims, this decision has not put the issue of abortion to rest. You have probably all seen in the news the countless stories of pregnant people experiencing acute health crises, being denied care due to the ban's chilling effect on physicians. So this has had resounding impacts on the health of people who not only need abortion care, but also miscarriage management, and other life-saving reproductive health care, including many people with highly desired pregnancies. We've seen that Texas is suing the Biden administration for simply reminding hospitals of their obligation to comply with the federal law that has been on the books for decades that requires healthcare providers to provide life-saving treatment to pregnant people. And we've also seen that, for instance, the Indiana Attorney General is investigating Dr. Caitlin Bernard for providing abortion care to a 10-year-old rape victim from Ohio. So these extreme examples just go to show that anti-abortion extremists are absolutely going to the mat to force people to carry pregnancies and to deny them medically necessary healthcare, even in the most extreme scenarios. And we know that there will only be more novel and complex issues related to potential cross-border enforcement of abortion bans and criminalization of abortion assistance. For instance, the Texas Freedom Caucus sent a cease and desist letter to an international law firm that had made a commitment to provide support to staff who needed to seek abortion out of state. And we've seen that some abortion funds, including in states like Texas and Kentucky, have stopped operating for fear of liability. So at the center and in collaboration with other litigating groups, our immediate priority in the short term is doing everything we possibly can to preserve access on the ground for as long as possible, because every day, every hour that clinics are able to continue providing abortion care means that people who need abortion are able to chart the course of their own lives. We've filed multiple emergency lawsuits in states across the South and the Midwest, and have succeeded, at least temporarily, in restoring access in states like Louisiana, Utah, West Virginia, and Kentucky. Some of these lawsuits have been procedural challenges, arguing that trigger and pre-roll bans can't be enforced because of the way that they were enacted or because they conflict with one another. But there are also a number of cases that seek to enforce an independent right to abortion under state constitutions. So in all of these efforts, physicians' voices have been absolutely crucial in lifting up the devastating harms that have been unfolding on the ground, whether that's through public education and op-eds, policy advocacy via congressional testimony, or litigation advocacy via expert declarations. It's crucially important for physicians who are on the front lines to sound the alarm and continue sounding the alarms about the horrors that patients are being subjected to. I think a really compelling example is numerous physicians in Louisiana, including many who are not themselves abortion providers, have submitted affidavits in the trigger ban litigation there, detailing their fears about how the trigger ban would impact their patients, as well as the ability of medical students and residents to get the training that they need to provide comprehensive reproductive health care, and the impact on just the overall health of people who live in Louisiana. So this testimony has been, incredibly powerful, huge value add to that litigation, and is a really important way that physicians can get involved in our litigation advocacy. So I will stop there for now and turn it back over to Becky.
Alice, thank you so much for that overview, and thank you so much for the work you and your colleagues are doing. We know it's been lots of long nights and work, and so we're so grateful for the work you have done and will continue to do. And with that, I'll turn it over to Skye to tell us what all of this might mean specifically for MFM practice.
Well, hi, thank you so much for having me. And Dr. Stone, thank you for convening this and for creating the space. And of course, Alice and your team, thank you for everything that you're doing for all of us on the ground in so many of these states. As Becky said, my name is Skye Perryman. I'm the president and CEO of Democracy Forward, and it's nice to see some familiar faces from the time that I was at ACOG and got the pleasure and honor of working with so many of you on a day-to-day basis. Just a brief background on Democracy Forward. We're a national legal organization that was founded in 2016 or 2017 in the wake of the 2016 election, with an acknowledgement that we were entering a new phase of American life where the very foundations of democracy, the hard-fought battles that we would love to think were over and that one could move forward, were going to become more at threat. And so Democracy Forward focused the first 4 years of our work on challenging unlawful policies of the Trump administration that without additional bandwidth, the legal community that existed would not have been able to handle, working alongside many phenomenal partners such as medical groups and litigating organizations. And then now we have expanded our work and are doing a lot in states and local governments, as well as amplifying the voices of people that have an interest in democracy, which of course the medical community and scientific and researchers at both the state and federal level. So that's a bit about us. And I see Tatiana has put who's our wonderful government relations and policy director, has put our website in, and we encourage you to go there. And it has been wonderful to get to work with SMFM on vaccine defense issues and on women's health and reproductive healthcare issues. So thank you again. So I will just start in about, to say a few things on the specific implications. And you all here are living this every day. And so please put questions or thoughts or comments in the chat. And I know Erica and Alice and I would love to engage with you on those, both in the chat and during the question and answer period. So please keep those coming. But I will say that I think while many and we have known that there was a concerted and announced effort to overturn Roe versus Wade to restrict access to abortion for many years. I do believe, and I think you're seeing this, that even though that was known, the country and medical professionals specifically, and frankly, lawyers specifically in our profession, are still reeling from that decision, and that we are really in uncharted waters for right now. And one of the things that we hear a lot from medical professionals, and I know that you all are facing in your practices, is that among many of the challenges that the Dobbs decision presents, really the criminalization and the idea that what the court did here was not issue a narrow ruling that restricted access in some cases or that further hollowed out, precedent, but left some intact. But the ruling really does enable states at this point to enact criminal penalties. And while there's a lot more, lots of other civil penalties and things and licensure and that are very problematic as well, I think that is really where we're seeing and hearing from medical professionals and others, institutions, that's really making this incredibly hard to chart. I will also say that I think it really puts in center focus the role of both MFMs and OBGYNs more generally, and other physicians and healthcare professionals that provide reproductive health care, but also the importance of your institutions and your medical societies like SMFM and ACOG and others, because what will happen, and I'll walk through sort of some of the things we're seeing, but what will happen is it will be incredibly important to rely on guidance when charting these waters together. And because of what you all do, providing care to high-risk obstetric patients, we know that in many of the ban states, and I'll kind of walk through some of those, there are exceptions for health and life, not in all circumstances, but there are some of these exceptions, and you all really practice in many cases at the intersection of those exceptions. And I think a lot of work will need to be done in the coming days. And I know SMFM and others are committed to this in helping to define the contours and to provide supportive information about what types of scenarios arise where there are circumstances where, in order for the health or life of a patient to be preserved, abortion and pregnancy termination is necessary. So I just will say a plug-in for all the work that has been done, the tremendous work that you do through SMFM, but the work in the future that will matter, and it will matter both to your practices and to other practices. I will also say that I know that many of you, and please put things in the chat, that many of you are, currently involved in situations where you're seeking legal advice, where you need guidance. And I know that there has not been the guidance that you would want and the clarity that you would want at this time. And I think the legal community is aware of that. I think your institutions are aware of that. And I just want to give space for that frustration that that I can't even pretend to understand what you are, going through every day. But I will tell you, I'm going to try to give you some overview of some things that are moving and happening. But I will tell you that I think, unfortunately, this is going to be a very long road. And I do believe that it will never become so simple, and it will never become so clear in some of the really, the states that are restricting access or banning access or targeting you. But I do think that the community is coming together to figure out how to chart these uncharted waters together. That includes medical societies like SMFM. It includes lawyers like what Alice and our team and others do every day. It includes academic institutions. And so I do think that, the map is in the making, and it's not going to be easy answers, but I think that there will be more clarity. And I'm going to try to kind of give you an overview of what we know today. But I just wanted to give space to that, and that I understand this conversation and all the conversations you're having are probably likely very unsatisfying, because there are not clear answers. And we are talking about being in a world now where there are extreme penalties, including criminal penalties, that really put at risk even, all of you. I mean, even for those of you every day use your life to serve others, but they put at risk your ability to serve others and to care for people and to care for moms longer term. And I know that's also, equally concerning, in addition to the personal sacrifices and personal threats and liability that this presents. So I just wanted to give space to that, and I'm sure we'll talk about it in our question and answer period. So I will give you a bit of an overview of what's happening in Washington, and then some things that we're seeing dovetailing on some of the comments that Alice made in the states, and where I think things are going, things to watch. And then I will commit to you, and I know everyone on this panel will commit to you, that we will be in community with you, and that as clarity arises, I know that we're all willing, and SMFM is willing, to sort of continue to provide these types of resources and spaces and forums. So you have heard, and I believe groups like the Center for Reproductive Rights and others have been active in advocating for this, that there have been calls to the federal administration to declare public health emergency around this issue. The reason that is seen by many advocates as important is that it enhances the power of the federal government to take actions in order to protect people and communities throughout the country, similar to what we have seen with the COVID-19 pandemic. I don't have crystal balls, and as a lawyer, that's never a good idea. So I don't have one. I will tell you that I think many think that this may be somewhat unlikely, but advocates are working really hard to try to push that through. And again, I don't have a crystal ball. There's a hearing happening today at the Energy and Commerce Committee as we're talking, and the president of the AMA and others are there. So, I mean, that is something to watch. But it doesn't help you in your day-to-day practice right now, but it is something to watch and to be following. You saw, and Alice mentioned, that the federal government has clarified a long-standing rule reminding people about EMTALA. And what I would say in terms of your own practices, as you know, is that it is a narrow sort of responsibility that would imply to life endangerment in emergency settings, but it is really important, particularly in states that have very draconian bans or are seeking to have draconian bans where there isn't even sort of broad exceptions. It is important, I think, for you to know, and when you're interfacing and talking to people, this is not new. This isn't something that sort of, just was made up yesterday or a new solution. It is a long-standing obligation under federal law. And we have seen the Biden administration remind folks of that. I'm sure your institutions are seeking to provide, I would hope, guidance around sort of EMTALA. And if they're not, maybe that is an ask that you can make, or at least to start, convening and working with people, because it is an area where in some of the highly restricted states, and I saw, folks from my home state of Texas and others that are on the webinar today, it is an area that could provide some ability for physicians to be able to take care of their patients. The Texas suit that has been filed that Alice mentioned is a typical strategy that we've unfortunately seen from that attorney general and from other attorney generals. It was filed in a jurisdiction that has shown itself to be hostile to constitutional rights of people, to physicians, and to science. That said, you know, there are broad implications for our democracy and our overall system of government when the balance between state and federal laws and this sort of federal preemption and others, you know, will come at play. And so this would be a new type of challenge. And, you know, again, we don't have crystal balls and we can't predict. And we do know that the law in this country clearly suggests that the federal government, that practices of states cannot conflict with what the federal government and federal law requires. And so we will follow that. We can keep you updated on that. But right now, EMTALA, it's an age-old law. It's not new, it's in effect, and you know, you should engage with your personal counsels or with your institutions on how that applies, but it is there. And I think some of this is there's a lot of reasons for doom scrolling. You don't even have to doom scroll because you're living it every day, but where there are some protections and clarity, we need to be clear about that because you want to be able to take care of your patients in the way that you can. And so, you know, you should always be asking your institutions and your personal counsel and others, you know, about these areas where laws and protections may still be in effect that would allow you to provide care. And of course, we do know it's a state by state and in some cases a community by community situation, which is what Alice and her team are doing to try to preserve as much access as possible. You all have probably seen stories, and of course, SMFM has played such a leading role in access to mifepristone and to medication abortion. So I'll just say that for those that are familiar with this advocacy that SMFM engaged in during the pandemic, at ACOG, when I was there, we brought a case alongside other institutions against FDA to have the in-person dispensing requirement lifted during the pandemic. And were successful in that case until several days before President Biden took office. The Supreme Court blocked that injunction. SMFM supported that lawsuit on a broad-based supportive medical amicus. And then after the Supreme Court stopped the ability of, or after the Supreme Court sort of stopped the relief in that case, as soon as the Biden administration took office, SMFM joined ACOG on a very important letter and advocacy strategy that ultimately ended up with FDA temporarily lifting that requirement, which of course we saw in December. After a full review of the evidence, FDA has said that it will continue to exercise enforcement discretion and that there's now revised labeling that is being considered by the agency that will lift the in-person dispensing requirement on the medication. Now, you may be saying, what does all this have to do if I'm in a banned state or if I'm in a state that restricts abortion? And what you've seen in the news, according to public information, is that the generic manufacturer of the medication abortion pill, GenBioPro, has said that they do intend on bringing litigation in order to, again, this is a federally approved product. Mifepristone is a federally approved product, and there are major questions and major concerns, like states cannot limit access to federally approved products or ban federally approved products. You saw the president mention that in his speech the day the Dobbs decision was released, and you saw the attorney general clarify that in other statements. So that is an area to watch as providers and could potentially provide some additional paths for access, or at least keep access paths intact. We can again update you as those things continue to move forward. As you know, mifepristone is also used as a standard for miscarriage care, and we know that there is efforts underway to actually be able to include an affirmatively approved indication for miscarriage care. And so that may have some implications down the line. And then, of course, I have to mention, because it's an area for you all to watch, you know, misoprostol and other medications that you all use, we are starting to see in the states, states seeking, Texas, after for years saying that they define medication abortion sort of as mifepristone, is now suggesting that MISO and others are sort of subject to its penalties and restrictions. We are seeing that trend, you know, in other states as well. That said, you know, I think many advocates are viewing misoprostol access as a potential pathway for care. And so those are all areas to watch, and areas where I think you will see the community of advocates, you know, everyone, again, it's a democracy issue. It's like everyone in society that has a position here, whether it's the manufacturers and businesses, whether it's providers like you all or others, sort of looking there. And then, of course, the federal government has said that it is committed to this notion of federal preemption. So that's just one, that's another area to watch, and where you may see, you will definitely see, I think, implications for your practice. And then Alice mentioned, you know, interstate travel issues. What I will say is on a few other areas, for those who are living in states that are not restricting access to abortion now, I think that there is a lot of work that will be done with many of the you know, advocates, and really a role that you can play in fortifying access there. And so that is, you know, again, something to keep in mind. And then I do think in the restricted states, what we have seen, and what we have seen even nationally, is that it's not over. It's hard. You know, you can lose a lot of hope here, but there are fights to be fought, and immediate ones that have to be fought, the ones that Alice and her team are fighting every day. But also, there are people now saying that they want to look at a national ban on abortion. There are states that are saying that instead of criminal penalties, they should be even more severe. We are seeing some of your colleagues that have been threatened and targeted in the news. So the notion, you know, there's a lot of work to be done to both sort of try to preserve what we have now, as well as make clear and demand that this is not unacceptable in a democracy, and to try to move that needle forward in other ways. So I'll just, you know, that's just a plug for, we want to stay engaged and in community with you, and there are fights to be fought now where you can have a really big impact. So I will say a few things about that, then we'll move to the next piece. So move to Erica. You all know every day that your advocacy matters, and Alice, you know, mentioned that. I will tell you, it will be critical to stay involved in medical societies and to stay involved with your institutions, to lean on medical societies like SMFM and ACOG and others when you need help in navigating your institutions, and to be involved in public advocacy. And like I mentioned, the president of the AMA is testifying today. We have seen time and again in cases where you all weigh in as amicus that really does work. We saw how your efforts helped enhance access to mifepristone, that even allowed us to be at this place where there's not going to be an in-person dispensing requirement. So do not think that your voice doesn't matter. It may not matter right now to certain people on the Supreme Court, but we have seen where it can really make a difference. And doctors continue to have such a role. I will tell you that because you are practicing at the intersection of a lot of the medical exceptions, and this, there will be, I believe, a lot of opportunity to participate in storytelling, in research calls, in documentation. I know SMFM will bring a lot of those opportunities to you. We will as well, but please stay engaged there. And of course, as Alice mentioned, we're seeing massive amounts of stress, not just on clinicians, but also to abortion funds. And so ways that you can promote, you know, donations there or other things are also important. I will end by saying this is not the end. We are on a long, long road. We have seen time and again how people using their positions in power can help turn the tide. And I know that with this group, we can, but we know that the attacks will continue to come. And so one of the best things that you can do, and that I know are committing to you to do, is to stay in community with each other, to share your experiences, to find ways to engage, and to find ways to have hope in this time, because that is going to be what will carry us forward. I'll turn it over to Erica.
Yeah, thank you so much, Skye, and thanks for ending on a high note. We will, I'll pull up your slides, Erica, and then we'll get started.
Thanks, Becky. And thanks all of you for joining today. And particularly thanks to Alice and Sky for just being here and providing us so much amazing information. As Becky mentioned, my name's Erica Werner, and I'm really pleased to be here today and talk about SMFM's ongoing work to address member needs and concerns regarding the impact of the recent Supreme Court decision. For hopefully a little less than 10 minutes or so before I turn it back over to Sky and Alice to offer more of their amazing expert advice, I'm going to provide a brief overview of our society's work in response to the court's decision, with a focus on member needs, advocacy, and education. Before we dive into what SMFM is currently doing, I did want to just provide a bit of history about our past work in this space. There's been a lot of work in the last few years, and that's in large part due to that in 2019, we received a grant to enhance the society's work in the reproductive healthcare space. With that funding, the society created the Reproductive Health Project with a goal of reducing the rate of maternal morbidity and mortality among high-risk pregnant individuals in the US. Led by the Reproductive Health Advocacy Advisory Group, which is an interdisciplinary group of clinicians and patient advocates, the project has accomplished much in the past 3 years. You'll find a number of those accomplishments listed here. I won't go through all of them, but the Reproductive Health Project has supported the development of clinical publications, educational offerings, and advocacy and communication efforts that have supported SMFM members and advanced evidence-based reproductive health options for high-risk pregnant patients. Much of this work has been in collaboration with a broad range of partners, including clinical, legal, and advocacy organizations. For example, our clinical partnerships have included development, review, and endorsement and collaboration dissemination of publications, and our legal partnerships have resulted in the filing of several amicus briefs, which Sky alluded to, supporting key litigation, preserving access to care. In the months leading up to the Supreme Court's decision in the Dobbs versus Jackson Women's Health Organization case, SMFM worked really hard, and the work was really based on setting a foundation in clinical guidance, including new guidance regarding the use of analgesia and anesthesia for maternal-fetal procedures. This evidence-based informed our contribution to the legal arguments surrounding the case. The Reproductive Health Project Advisory Group then led direct action in support of our members' provision of evidence-based care by joining partners in a rally at the Supreme Court and meeting policy members to advocate for access to abortion care. I personally was at this event and felt incredibly proud of SMFM's voice at that rally. We can go to the next slide now, Becky, thanks. Despite our clear advocacy efforts that abortion care really is healthcare, we are all acutely aware of the most recent decision on abortion rights. I hope that everybody on this call saw SMFM's swift response to the Supreme Court decision. I know it gave me a little bit of peace of mind on that day. But in addition to our independent statement, we also issued a statement that was in coalition with other medical groups, including one that we coordinated with a focus on maternal health, and one that was released 2 weeks ago that included 75 medical societies and organizations. We disseminated an all-member email with important actions members could take, and we continue to develop resources and tools to share on our website as we speak. On the advocacy front, we're signing on to the amicus briefs with ACOG and AMA in support of challenges to state abortion bans, and we're working in coalition to advance proactive legislation at the federal and state level. In addition, we've been fielding multiple calls from reporters seeking comments from our member experts and wanting guidance about the impact these restrictions will have on access to care and maternal morbidity and mortality. Members are also writing about their experiences independently, and we so appreciate that you guys are all doing that. I just hope that you'll continue to share that work with the SMFM team as it gets published so we can promote it. In addition to our initial response to the ruling, we're now implementing a multi-pronged effort to support members through ongoing communication, convening and educational events, ongoing advocacy, and new resources and publications. We'll be engaging in ongoing communication with members about our work, like the awesome forum today, and in particular, driving member inquiries to the Reproductive Health Project email, which we'll put up at the end of this. By centralizing communications through that one email, we hope to monitor trends in member needs to be as responsive as possible to the ongoing challenges. We really appreciate hearing from so many of you. And in particular, I want to mention one thing that we're actively working on that came specifically from one member. Somebody reached out with a really wonderful idea that we should be using the Find an MFM tool on our website to provide enhanced provider information to help facilitate referrals. And the MFM staff jumped on that and are currently working on that. So more to come on that. One request that we've received from many is some mechanism for members to communicate with each other about the challenges faced by those practicing in restrictive states. And to provide the safest space for these discussions to happen, we're planning to have a small piloted facilitated convening of cohorts of members, perhaps organized by region, but we're still trying to figure that out, that would allow people to meet virtually over the course of a few months to provide mutual support and the opportunity to share resources and strategies, as I think those of us in less restrictive states are really aware of the emotional burden of this, in addition just to the pragmatic burden. So more to come as we implement those ideas. From an advocacy perspective, the work is constantly ongoing, and the SMFM Health Policy and Advocacy Committee and staff have been developing resources for members and strategizing about the most effective activities and partnerships to elevate MFM priorities into policy debates. In addition, we're leveraging our partnerships, as you've already heard about, with other organizations, including ACOG, to ensure that MFM perspectives are included in the broader efforts. We've been working with ACOG state legislative staff to develop a coalition of clinician organizations with a shared goal of protecting and expanding access to reproductive healthcare services, including abortion, across the United States and through state advocacy. By amplifying the advocacy efforts of colleague organizations, engaging in joint advocacy initiatives, connecting state advocacy efforts, and engaging in information and resource sharing, we really feel that we can maximize SMFM's effort in this space, as we are a somewhat small but yet mighty organization. The publication committee also has begun addressing member needs for guidance regarding clinical consideration. Just one example, SMFM recently endorsed the Society of Family Planning's interim clinical guidance on self-managed abortion, filling a gap in SMFM guidance that's sure to be useful to our members in the coming months. To address the educational needs of members and fellows, the Reproductive Health Project Advisory Group is planning a series of webinars on a range of topics, in addition to a fellow lecture series webinar on the clinical implications of the decision that's going to be August 3rd. And finally, with regard to the annual meeting, we're planning robust multidisciplinary courses that will include clinical issues, advocacy, legal concerns, and emotional support resources for members. Again, we're going to be leveraging our many partnerships with organizations with expertise to offer on these issues, and hope the breadth of the programming will meet the needs of a wide range of members practicing in both restrictive and permissive environments. In a somewhat bleak time, I think of this slide as sort of our slide of superheroes. The project's efforts include work across several programmatic areas within SMFM, and the staff shown here from the publications, education, and public affairs team are all engaged. This work is truly a team effort and reflects the hard work and commitment of all those on this slide and many other SMFM staff members. We are thrilled that Alicia Lukowski has recently joined SMFM to lead this work. She brings decades of experience in the reproductive health space to inform our efforts. Additionally, we're welcoming Samantha Berg to the team in early August, and Samantha will be managing our advocacy efforts at the state level, a crucial strategy in addressing the impact of the Supreme Court's recent decision, and the first time that SMFM has really had a dedicated state advocate, which we obviously need at this time. And so finally, to close, I personally have been really proud of SMFM's leadership in the wake of this decision, but we all know that there's lots of work to be done and lots more things SMFM could be doing, and we want to hear from you. So if you have questions about the work we're doing, if you want to share your experience navigating through the changing landscape, or if you have ideas for SMFM to consider, we want to funnel everything through this email address, rhproject@smfm.org. And with that, I will turn it over to Becky to go to question and answers. Thanks.
Thanks so much, Erica. And I am just peeking through the chat and I don't see any specific questions. If anyone has any questions for our panelists today, you can raise your hand under that reactions tab. Oh, I see one from Dr. Hackney. If you have not been following Dr. Hackney on Twitter or in the New York Times, he has been just such a tremendous voice on this issue. And his question is, what is the mechanism for requesting consideration of an amicus on the state level? So I might turn it over to Alice and Skye to address that.
Alice, do you want to say, I have some familiarity with how their process works, but if Alice, if you want to say a few things.
Oh, I mean, you can go. I didn't have much to say beyond that. Like, we really appreciate SMFM's expertise, and in any case where there are these like complex issues, especially related to high risk obstetrics or just the medical science, then we super appreciate amicus briefs from SMFM, ACOG, and other medical societies.
Yeah. So I'll just say. Dr. Hackney, and it's good to see you on here. So I think from SMFM's perspective, you should make that request to the staff of SMFM. If you're aware of something that's going on and you think that SMFM would be a powerful voice, you should make that to the staff. They will work to contact the folks that are litigating the case, which may be Alice and her team, who knows who it would be, and make sure that what you have in mind would be helpful, and then would reach out to other medical groups to see if there's something underway. And then if there's not, can work to do that. I will, say we have supported the medical community in a range at Democracy Forward, in a range of amicus briefs, and there are lots of attorneys, both in nonprofits or in private law firms, that are willing to do this pro bono, so that it's no cost to the society or to its members. So I would, folks can correct me if I'm wrong, but I think you should just make those requests straight to the SMFM staff, and they will know how to navigate that. We work with them often on navigating those types of things. So
Skye's 100% right. You can email Becky, Alicia, Carrie, you can send me an email, but I think they are happy to do this.
Thank you. And we have a question from Sarah in Tennessee. And I don't know, Skye, you're nodding your head like you're.
Do you want me to try to take this? Do you want me to try to take this? So this is what I'll say. And thank you for being in Tennessee. As somebody that grew up in a state that has now banned all abortion, the fact that folks continue to practice in states where there are severe restrictions and threats is truly amazing, and you've touched so many lives. I will say that I've been really encouraged by hearing, generally the advice is that, like, societies or other groups just can't advise you unless you have an independent sort of private attorney-client relationship. That said, we know there's a lot of need. And so there are efforts underway right now with the society's SMFM, first thing right after Dobbs on the phone about this, to figure out how to be able to see if there's ways to provide resources. And so I know that there may be some immediate information about just kind of places that you can contact. And then I do think, as I said, it's a long road, and there are groups working on getting some resources stood up to navigate these waters, which are different waters than I think people thought we would be in. And so I'll just say, I think what Erica said, if you can let SMFM's team know through the email, through other things, what needs you have, even if they can't provide that advice, which they can't provide you individual advice, they can sort of understanding where the needs are. The communities are trying to build, legal and medical communities are trying to build resources for you. So I think I know it's not completely satisfying, but that is, you know, there, and it's very important that you make these needs known and heard so that as resource decisions and things are being set up, they can be set up in effective ways. So thank you for raising this today and continue to reach out.
Can I just add, this is one of the things that we've heard from many members, and it's not that we're not hearing it. I think the board sort of has set up this RH, it was up in the chat earlier, and it was on the last slide, but just if you email, they can keep track of what kind of legal advice you'll need in what states, and then work with groups like, you know, Sky Analysis Group to make sure that we're meeting that need.
Okay, so life limiting conditions in states such as Texas, general advice do you have from MFM to their ability to counsel regarding options, and understanding we're not providing you direct legal advice? Like Alice, do you want to say anything about the counseling pieces, or is that still pretty uncharted? I know you guys are litigating the Texas, have been litigating the Texas pieces.
So I would say that a lot of these questions are quite uncharted territory, and it's hard to offer specific legal advice without looking at the laws of the jurisdiction. Unfortunately, a lot of issues are going to be resolved, I think, through litigation. Now, of course, it's the center's position that simply providing options counseling to a patient is protected under the First Amendment, but I can't really provide, you know, specific compliance advice.
And I'll say that, you know, in Lebanon, Ohio, and in many of the challenge that we're challenging abandon, and many of the challenges that the centers brought, you know, depending on how it's interpreted, if it could be interpreted really broadly, you see those First Amendment claims. I mean, there are many reasons that lots of attempts to prevent people from doing things they should be able to do are unlawful, but we don't want to put you at risk by suggesting that there's, you know, more clarity there in terms of how the Texas courts would look at it. I think, I do think this is an area where I think this is an area where the medical guidance that a lot of the institutions are, you know, framing for this time, as well as legal guidance, will continue to become available. And it's, I do think that to the extent you have examples of situations where you felt as if you weren't sure if you could counsel, or you had to go like call a lawyer before you even said something to your patient, documenting that and the stories and the are going to become incredibly important. We know that the majority of people in this country believe in a basic right to pregnancy termination and abortion and reproductive health care. And we also know that there have been efforts to cover up how sort of draconian much of this is. And so your voice is going to be very important in enforcing that accountability.
So I see we're at time and there aren't any other questions in the chat. And so, but I know there's lots of questions. I know you guys are dealing in this really unprecedented, uncharted time. And so please, you know, Alice put in the chat, document +1 a million times. Use that inbox, send us stories, even if it's just, I had this awful experience with a patient today and you just want to like vent it out into the world. We're ready to accept that and would love to get it from you. And we, and any of your concerns, please send them to us. We can start to prioritize what we're going to do to help you all. Thank you all for joining today. If you have any follow-up questions, please reach out to us. And I want to give a big thank you to Alice and Sky for being here for today, for taking time out of their busy schedules to talk to us and continue to be a resource. We really appreciate what you've done and what you will do. And of course, Dr. Warner for leading us on this journey, and to Dr. Stone for opening it up and being such a strong supporter on these issues and such a strong leader for society. So thank you, everyone. We'll be in touch about our next opportunities and look forward to hearing from you as well. Have a good day and enjoy your week. Stay hot, cool if you're in the West or really anywhere. It's very hot. Bye, guys.